Welcome everyone to our talk about probate and estate administration and our thematic review into this area. My name is Mel Lothbrock and I'm a regulatory manager in the thematic risk team.
And my name's Siobhan Fennell, and I'm also a regulatory manager in the thematic risk team.
So before we start, I'm just going to talk a little bit about the reasons why we decided to do this thematic review. People typically access probate and estate administration services at a stressful and vulnerable time in their life. Firms and solicitors in this sector are dealing with a huge range of sensitive issues. They can be dealing with complex family dynamics, managing large amount of client monies and estate assets. So there are obviously some significant risks here. When it came to thinking about the reasons behind this review, the SRA conducted an annual assessment of continuing competence in 2023. And that assessment found that probate and estate administration was the area where there were the third highest number of reports to the SRA and complaints to the legal ombudsman. Out of the compensation fund, the payments that were as a result of probate and estate administration were also the largest and most frequent. We decided to do a thematic review into probate and estate administration legal services to look into some specific things. So I'm going to move on to what exactly we did. This review looked at how firms and solicitors maintain continuing competence, manage the risks around handling client monies and estate assets, and how firms and solicitors were meeting their obligations to clients and parties to the administration. In addition to firm visits, which I'm going to talk about in a second, we also met with a variety of external stakeholders that work in this area. So that included the Society of Trust and Estate Practitioners, the Legal Ombudsman, the Law Society Private Client Section, the Institute of Chartered Accountants in England and Wales, and the Competition and Markets Authority. We had some meetings with them to share their insights into the challenges and opportunities in this sector. Moving on to the firm visits. The main area in which we gathered our data was through visiting 25 firms that carry out probate and estate administration services. We selected firms that had more than 10% of their annual turnover from this area of work. And within that criteria, we then randomly selected a range of firms to reflect the market spread of this sector. We saw 25 firms that were of different sizes in different regions across England and Wales, different practice structures from sole practitioners to larger regional firms. And we visited them in person, but also virtually. At each firm, we interviewed the head of department or the person with overall responsibility for probate and estate administration at the firm. And we also spoke to a fee earner who was conducting files, probate and estate administration files, where available. Obviously, in some firms, this was the same person, in sole practitioner firms, for example. We also reviewed 2 files at each firm and the client and office ledgers linked to each file. We reviewed training records, policies and procedures, and accountants' reports at each firm as well. As a result of this review, the outcome will be that we will publish a report, and it will include all our findings from our firm visits, and some case studies and recommendations on good practice. And this will be published in the next few weeks. I'm just going to hand over to Siobhan to talk about what we found.
Thanks, Mel. So yeah, I'm going to talk about some of the key findings from our thematic review, and really some points of best practice that we hope people will find useful. So these are really the headlines from our report. So the first finding was around vulnerability. So we found that firms offering probate services had a really good understanding of the likelihood that their clients may be vulnerable. We saw a number of examples of good practice by firms in identifying and addressing client vulnerability. We saw one firm who were providing training on vulnerability to all new staff within their probate team, and they had a policy which really informed how their staff identified vulnerability and provided support in addressing different client vulnerabilities. This was really positive in addressing the needs of vulnerable clients, which was really great to see. In terms of client care, we saw some really excellent examples of firms' guides to probate and information leaflets that explained issues such as the role of executor and beneficiary and the probate process for consumers. That wasn't the case in every firm, and we would like to see a greater proportion of firms providing that type of information so that clients and other parties to the administration can understand the process. That's really likely to reduce the likelihood of misunderstandings or mismanaged expectations. In terms of cost information, we know this is really important for clients to understand what costs they're likely to pay. And we found that clients were not always receiving the best possible cost information. Around half of all firms were not explaining when and how costs would be paid, and a small minority provided little, if any, cost information. We also found that some firms were exceeding estimates without notifying their client in advance, and that firms were not always providing residuary beneficiaries with cost information when the firm was acting as executor. We know that poor cost information is a driver of complaints to firms themselves and to the legal ombudsman, and we would really like to see improvements in this area. We highlighted to the firms that we visited that the legal ombudsman publishes a really useful guide to good cost services, which can really help firms in making sure they're meeting their regulatory obligation to ensure their clients always receive the best possible cost information. And in terms of complaints handling by firms, we were really pleased to note that all firms had provided their clients with a copy of their complaints procedure. And we saw some great examples of firms sharing learning from complaints with their staff and using learning from complaints to improve their processes and their client service. Unfortunately, we did see instances where clients had expressed clear dissatisfaction with the service they were receiving, but that hadn't been addressed by the firm as a complaint. It's really important that all staff within a firm are aware that a client doesn't need to use the word complaint in order for the complaint process to be invoked, and that any clear expressions of dissatisfaction by clients should be addressed under the firm's complaints procedure. Doing that can really help to ensure that complaints are resolved promptly, and it avoids the escalation of complaints beyond where they need to be considered. And then moving on to the next slide, we also looked at how firms handle situations where the firm or a member of the firm is acting as executor on an estate that the firm are also administering. We found that most firms we spoke to had a really good understanding of the risks of conflict when they're appointed as executor. For example, the risk of conflicts with joint executors or with residuary beneficiaries. And some firms took really proactive steps to avoid the risk of conflict or perceptions of conflict by other parties to the administration. So, for example, some larger firms arranged that the appointed executor did not also administer the estate, providing additional oversight, and others put in place additional supervision, and some provided a much greater level of information to residuary beneficiaries where the firm was also executor. These were all sensible and relatively low-cost measures that can help avoid disputes and potential conflicts, and we'll be sharing this best practice in our review. And then lastly, we looked at whether firms had obtained an accounts report within the necessary period of time. We were really concerned to find that 2 firms we visited were unable to show us that they had obtained an accountant's report for their latest reporting period. Both those firms are now being investigated in relation to this. And this information was passed to colleagues managing our ongoing consumer protection review, as obtaining an accountant's report on time is such a fundamental part of ensuring that client money is appropriately protected. We know that most firms fully understand the importance of complying with this obligation, but where firms fail to do so, we will continue to take action. And then moving on to our final slide. Um, Further action will be taken. So, in terms of next steps, Mel explained at the beginning that we will be publishing a report that will set out the findings and some checklists and best practice that we hope firms in this area will find useful. We're also feeding our findings into the SRA's continuing competence programme, so we can use that as part of our evidence base in terms of deciding next steps as an organisation. And our continuing competence programme, which looks at supporting solicitors in ensuring that they are maintaining our competence. Again, we'll be feeding our findings into that ongoing programme of work to ensure that we continue to support solicitors in that area.
So that is the end of our talk today. Thank you very much for listening to us. We really want to hear what you thought of this talk and today's events. Was it useful? What type of content would you like to see covered in the future? It'd be really great if you could click on the evaluation link below this video and let us know what you think. It would only take about 2 minutes to complete, and we'd really appreciate it. Thank you again, and goodbye.